Now, a number of people have asked me, can Jess Phillips sue Elon Musk? Well, to cut to the chase, well, yeah, of course you can. Anybody can pretty much sue anybody. Doesn't mean you're going to get anywhere. And also, I just don't think she will. However, that's not going to pay for the diesel, is it? So to pad this out a little bit, I'll just go through and look at the details and explain what the issues would be in such a case. So what's this about? It's about a tweet. Elon Musk put out a tweet saying Jess Phillips is an R word, rhymes with grape, genocide apologist. Okay, and people are saying, well, she should sue on the back of that. So what are the issues? Well, the first issues would be, where would she sue? Because of course, Mr. Musk lives somewhere in the United States, and Jess Phillips lives here in England and Wales. So you'd look at what is the correct forum. Now, in a situation like this, with defamation, especially now it's all online and you can read the statements anywhere, you can sue where the statement was made, which would be the US, or normally you would sue where you have your reputation that you wish to protect, which in this case, of course, her reputation is pretty much within England and Wales. So she could issue the claim within England and Wales. She'd then need permission to serve outside the jurisdiction. And that's quite that's a topic for another day. But in the same way here, if you want to sue somebody, you have to do all the letter before claim stuff, and then you serve the claim form either by writing to somebody's address or personal service. I mean, there are ways of alternate service as well. You can serve by email, but you need the permission of the court to do that, and you have to show you've sort of tried the regular ways. Would of course be for Mr. Musk to challenge where he was being sued. We have a thing called forum non-conveniens. In other words, that's not the right place to sue me. And you get into all sorts of issues about, where has the offending thing taken place? Where's the most convenient place? Where do the witnesses live? All that sort of thing. But Mr. Musk could theoretically challenge and say, no, if you're going to sue, you should sue me over here. I think even the courts would say, the English courts would say, no, we can actually deal with this. If it's a sort of a toss-up between lots of different places, I mean, the example we always used at bar school was an English bloke on holiday on the French side of the Alps throws a snowball that hits a German guy on holiday on the Italian side of the Alps, and he gets injured. Where does he sue? But in this particular case, I think the English courts would seize jurisdiction, because if it's a toss-up and it's like, well, yeah, it could be here or it could be there, it's the first court that gets seized of the matter that goes forward with it. Now, of course, if it were to be a situation in the US, unlike here, there's a case called Sullivan and New York Times in America, which basically says public figures, of which Jess Phillips would be a public figure, they can only sue for defamation if they can show malice. And that's malice in the technical sense. That is, the person made this statement either knowing it's not true or not believing it's true. We'd also get into, is it a statement of fact, is it a statement of opinion, but we'll come on to that. So it'd be a very, very high threshold with the First Amendment. I don't think she'd get anywhere in the US with this, because they'd say you'd have to show that Musk genuinely didn't believe this. And, I think that would be a very hard thing to do, because when it comes to showing malice, you have to show that all the facts are more consistent with malice than the lack of malice. So I think that would be an instant stop in the US. However, if she were to sue in England, what's the first thing she needs to show? She needs to show that the statement has caused her serious harm. Now, as an individual, that doesn't necessarily have to be financial harm. That could be personal harm. You have to evidence this. You can't just say, oh, it's likely to do this, with a few exceptions. But, she could say, well, this has exposed me to physical danger. I mean, the mere fact that, it's caused her problems, it's undermined her political status, it's raised all sorts of questions, that wouldn't be seen as serious harm, probably, especially for a politician. I mean, while over here the courts say, yeah, politicians can sue in their own rights, political organisations can't. It's just like, no, you've just got to take it, that's part of the rough and tumble of politics, but individuals can. And in fact, apparently we've tracked down at least 2 prime ministers possibly 3 who actually sued for defamation in the past. So, she could do that. And she could say, like, yeah, I am now getting, more abuse than normal, more threatening things. I mean, she'd have to show that it was on the back of that statement. But the first thing that the court would have to consider if she got off that hurdle was, what's the meaning of the statement? Because, usually in defamation we have a meanings hearing. And each side, the claimant says what they say the statement means, and the defendant says what they say the statement means. But ultimately it's up to the judge. And the judge will say, no, I don't care what you say, or I don't care what you say. I think the meaning is this. And we have that rather strange single meaning rule in defamation. It's a strange rule, and as the courts have said, if we were to start defamation from scratch, there'd be no justification for having the single meaning rule. But here it is. Interestingly, you don't have it in malicious falsehood. In malicious falsehood, if you can say, well, there's a potential meaning of the statement, that you don't have to particularly use any mental gymnastics you can get to. You can say, yeah, that's a legitimate interpretation. There may be others. As long as you can point to an innocent interpretation or one that you can prove, then that's fine. Whereas in defamation, which this would be, you have to say, well, what's your average hypothetical reasonable reader? Neither too prone to scandal and gossip, but also not too naive. What would they think it means? And this would get really, really interesting, of course, because you look at the context, first of all. Now, this is just a single tweet. And generally speaking, the court say, well, you just look at what the tweet says, and arguably this is just a flat statement of fact without any context. But I think the courts would accept that this is, and they've said this about stuff on Twitter, it's a very fast-moving medium of exchange. But yes, people might be expected to be following the story. So they would probably, I think it'd be easy to argue and say this is clearly in relation to sort of her comments and actions in regards to sort of all the gangs and the inquiries, or the lack of inquiries and all that sort of thing. So I think it would be relatively easy for Musk to say, I am commenting on this. This is what I'm commenting on. But then you'd get into sort of, what does it exactly mean? Now, interestingly, genocide, as a matter of law, has a very strict legal meaning. And at some stage, maybe I'll do a full history of, how, the offence of genocide arose, because it's quite sort of fascinating in itself. It's actually a guy called Raphael Lemkin, Polish Jewish guy, sort of like growing up in Poland, sort of interwar period and then into the 40s. You can probably see why he had some quite strong opinions on genocide. Now, his original definition was very, very wide, because it came from sort of, without getting into politics, an anti-colonial thing. Because his argument was it's about eradicating groups of people based on their identities. And he said you don't necessarily have to do that physically. There are ways of doing it, I'm sure my bias is here, because I always say, barristers are storytellers, and we are storytellers. So I see things in terms of stories. And I suppose, one way of looking at it is, if you eradicate a group, you can eradicate a group by removing their stories, everything that's special about them, whether that's their language, their cultures, their special days, their rituals. If you could sort of eradicate all that so they lose their identity as a group. And, this is the thing where you sort of see with like indigenous groups in different locations around the world where, people will come in and say, we are now assimilating you into the sort of broader national culture. And the argument there was, well, that is a form of genocide. That didn't get adopted within the offence. Some people refer to that as ethnocide. You're just removing everything that makes people different. But after much sort of arguing, there was a genocide convention which a number of countries signed up to, mainly so that they could, do the relevant prosecutions, sort of in Nuremberg. And that defines genocide as any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious group as such. And those actions are unaliving members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring around its physical destruction in whole or part. I mean, that's sometimes called genocide by attrition. So you don't actively target them, but you don't you starve them out, or you just make the conditions impossible to live in, or you sort of bulldoze where they are, or something like that. Imposing measures intending to prevent births within the group, or forcibly transferring children of one group to another group. Where you basically every time somebody's born, you sort of say, well, we're going to adopt them out and just bring them up within the dominant culture, or something like that. So it'd probably be hard, to say that that's a meaning. But of course, when it comes to meaning, the courts have specifically said, don't approach this as lawyers. Don't look at this too legalistically. It's about what people use in their everyday sense. So in the same way, for instance, robbery has a very specific offence in law. It's theft with the use of force or the threat of use of force. But if somebody came home one night and found their place sort of turfed over, and say, well, we've been robbed. And, you sort of go, well, technically speaking, that's a burglary. You can understand that it's just colloquial language. Or, somebody runs somebody over, in a traffic accident or something like that, some drunk driver. Then people might use the M word to describe that, whereas the offence would be causing death by dangerous driving. So the courts wouldn't look at it too technical. But also it's been qualified by the use of the R word. So it'd be interesting to say what they're saying. I think Musk would say something, because he seems to subscribe to this sort of great replacement theory idea that somehow it's attacking, because obviously, the ethnicity and race of the victims in this has been a factor. So you say, well, they're targeting a group or part of a group. So it'd be very, very interesting to see how that would be interpreted. And you can all discuss among yourselves how that might be. I mean, I always say that when you employ defamation specialists, what you're doing is you're employed to second guess what the judge is going to say. I think here the judge would probably say something like, well, yes, he's accusing her of basically, because of her actions, she is allowing an attack on a group, and it might not be genocide in the technical sense, but it's a hyperbolic way of describing this situation, especially with the R word qualification. I mean, we do use the R word in, because somebody's saying also he's accused, he said something about, Keir Starmer has R worded, the country, and again, it's that word has a very specific meaning in law, but it also has a generic meaning as well. Stephen Moffat R-worded my childhood, if you've ever been on any of the Doctor Who forums. So I think the court would look and say, well, this is, a hyperbolic way of describing a particular situation. But then you come into, well, does that mean, therefore, it is a statement of fact? Because there are a number of defences open to Musk. And one thing you can say is it's mere vulgar abuse. Because mere vulgar abuse isn't defamatory. If you just go and yell at somebody and call them all sorts of rude words, that might be unpleasant, but it's not actually actionable. I think in this particular one, it goes beyond mere vulgar abuse, because it is a sort of an allegation of something specific. But then we'd come on to, is it an opinion? In my opinion, her actions amount to this. Because, that opinion is a defence. Now, when it comes to opinion, you have to show, first of all, it is, an opinion. You have to identify the facts that you are basing that opinion on. And generally speaking, you have to show the facts are true, or it was reasonable to believe they were true at the time. So in this particular case, you would have to say, I am commenting, I'm giving my opinion on her actions or her lack of actions. And you can take that from all the context. And like I say, this would get back to this, would the court rule and say, yeah, most people who've read this tweet would know what it is in reference to. It has to be an opinion that reasonable people could come to based on those facts. It doesn't have to be an opinion that everybody would come to. I mean, that's the whole point of opinion, isn't it? That people can have different views on the same situation. But if you could say, I think a number of people, bear in mind what she has done or not done, I think it's fair to hold the opinion, that is tantamount to, or that amounts to, or this is a fair way of describing what I think about her. And I think actually he'd have a pretty good strong run on opinion, because although while it is quite hyperbolic, I think it is clearly expressed in terms of that is his opinion. Obviously, truth is a defence to defamation. I think it's true. I think she is doing this, and it does amount to a genocide. I mean, that might be slightly hard to prove. Another thing, though, is there's also, it's a matter of public interest. That's a two-part test, though, the defence of public interest. A lot of people conflate that and don't quite realise, because first of all, it has to be a subject that is in the public interest to discuss. And I think nobody would argue that this isn't a subject in the matter, in the public interest to discuss. Bearing in mind that the courts are very clear that what is of interest to the public is not synonymous with public interest. But in this case, yes, clearly this is a matter of public interest. But you also have to show it was in the public interest to comment in the way you did at the time you did. Sometimes this catches journalists out, where it's like, yes, it was a legitimate matter of public interest, but you making this statement or publishing this story in the way you did wasn't in the public interest. And that's why journalists will do things like they will have multiple sources. They will give people a right to reply. I mean, that's always the best way to sort of bolster a public interest defence, is to say, well, this is what I say about this, but I will give the subject a chance to respond. Either invite them to comment and say, like, I'll give you free time, you can say what you want, or just to report what they say. I mean, and this is why you always see things like in news stories, we approached Mr. X for comment, and he said the following, or he didn't respond. But then, you've got over the second limb of the public interest test, because you have actually allowed them, their say. Because the whole point is with defamation, if you just make a statement of fact, an accusation, an allegation as a statement of fact without backing it up, then it's like, well, how do you justify it? Whereas if you allow people, because people, you sort of going, well, please take my word on this. So you want people to believe you, and that's the whole point of making the statement, isn't it? Whereas if it's something where people can actually look themselves at the background to this and say, well, I hear what you say about this, but I completely disagree. I can form my own opinion, I can make my own mind up about this, then that takes the sting out of the defamation, because, even though you've made this sort of accusation, other people can have, form their own views on it. Another thing that might actually cause a hurdle is, you get into all this parliamentary privilege stuff, and I did a video recently about parliamentary privilege and defamation, and it is quite a confusing topic. I mean, feel free, it's only a few videos ago, so search it out and actually link to the judgment that discusses it. And I like to say, good luck trying to make head and tail out of what they say in that. But it used to be, if this is anything to do with her actions in Parliament, then of course she's got parliamentary privilege. But that swings the other way. Because you've got parliamentary privilege, if you wish to sue, people say, well, I can only defend this by referring to what you've done in your role as a parliamentarian. And normally I can't challenge that because of parliamentary privilege. So politicians would have to waive parliamentary privilege to be able to bring claims for defamation and say, okay, I'm suing you, but in order that you can respond, have a fair chance of defending this, yes, you can challenge, and the courts can investigate what I got up to in my role as a parliamentarian. So you waive parliamentary privilege. But now that's gone. Politicians cannot waive parliamentary privilege anymore. And that might itself just be a complete blanket ban on Miss Phillips actually bringing any particular claim, because all the defence have to say is, we cannot defend this without investigating her role, her actions in Parliament and as an MP. And we can't do that because of parliamentary privilege, and she's not allowed to waive it, so therefore our hands are tied behind our back. And there's no way we can fairly defend this. So, that would be the end of that. So, in summary, like I say, yeah, I mean, theoretically, she could sue, but she has all these hurdles to overcome. And also, as we always said, I've done loads of videos saying why you should never sue for libel, unless, you've got nothing to lose. I literally mean nothing to lose. You are completely you're completely unemployable. And you can't go out in public, and you're literally at rock bottom and it can't get any worse, then don't bother, because, you expose all your dirty washing in public and it all comes out. And of course we have disclosure then. It's like, well, we want to see, this is what you've said. We need to see what this discussion was. You'd have to disclose all your material and everything, all your comments, everything you've discussed with people. And it all becomes, up for grabs in court, and it all gets exposed in court. And finally, again, a lot of the time, people, do not accept the decision of the court. So even if the courts come forward and say, yes, you are completely vindicated, and we find this was a defamatory statement, lots of people say, well, I disagree. You know, I think the court got it wrong. Or, well, I don't care what the court said. Look at all this other stuff that came to light during the trial. I mean, it's a very unpleasant experience being involved in a defamation trial, which is why I never recommend it. But there you go. Like I said, people ask me about this, so I hope I have delivered. I hope all that made sense. I hope it wasn't too waffly. I hope you found it, as always, vaguely interesting, vaguely informative, and vaguely accurate. Yeah, and I shall see you next time. Hopefully for something that's not related to this. I'll try and think of some. I'm hoping there might be some interesting art law stuff cropping up, because this is ostensibly an art law channel, so it might be nice to have some art law on it. And I'll just shift to this side just to get my thumbnails, because I'll be going, hey Dan, do us a thumbnail please, and I can do all my various looks. That one seems to get a lot of views when I just like stare down like that. Oh, for people asking about the truck, yeah, the nice green flag man came down, but because we couldn't get the doors open, pretty much had to dismantle the truck from the ground up just to put some, just to get some power to the starter motor, which popped the locks, which meant we could pop the hood, which meant we could charge the battery. It's got a little key. This is great, classic. I love Land Rovers. Please sponsor me. That's one bit of sponsorship I would take. I do love Land Rovers, but they've got the little spare secret key for when you can't get in. But that only works if there's power to the truck, because it's an electronic lock. So it's like, what's the point of that? I mean, somebody said, it's in case your key fob runs out of a battery, so you can manually open it. But it's like, could you just put a lock on there so that I didn't have to, like the poor guy with like 2 hours underneath there in the freezing cold with me trying not to get him in the way. Luckily, because I've always been in Land Rovers, I know all the breakdown people really well. So it was actually the guy who rescued me last time when I took out a tyre in a row with a bit of flint up on Cambrai.